Assalamualaikum warahmatullahi wabarakatuh, and today our group will be discussing on the topic of Estoppel. So basically Estoppel can be understood as a doctrine that prevent a person from asserting something that is contrary to what had been implied by a previous action or statement of that person. Basically there are two types of Estoppel, and the first one is common law Estoppel, the second one is equitable Estoppel. Okay, the first one regarding common law estoppel can be understood as a rule of evidence that be raised in a situation which involve equitable rights or common law rights. Common law estoppel consists of few types of estoppel, such as estoppel by deeds, estoppel by representations, and also estoppel by record. Other than common law estoppel, there is another types of estoppel which is equitable estoppel. Equitable estoppel had been derived from the maxim, he who seeks equity must do equity. So from this maxim, it can be understood that when the parties in a contract had proceeded to perform a contract on the basis of the underlying assumption, neither of them will be allowed to go back to the actual position in the contract. But if one of the party from the contract seek to going back to the actual position of the contract, like there's nothing happened between them, the court will grant to the other party a remedy such as equity. So basically, equitable estoppel consists of two types of estoppel, which is promissory estoppel and also proprietary estoppel. However, in the scope of our country, Malaysia, generally we apply equitable estoppel, and it consists of estoppel by representation, promissory estoppel, and also proprietary estoppel. This can be seen in the case of Gan Tak Meng and others versus Ngan Yin, where the court distinguished common law estoppel and equitable estoppel, and the court said common law estoppel is more to rules of evidence, but the equitable estoppel covers rights and remedies and it more wide. However, basically in Malaysia, we does not apply only to the types of estoppel that I had mentioned before, but we also apply and derive the estoppel from the common law estoppel and apply it under the Malaysian Evidence Act 1950. Therefore, my other group members will be discussing on the application of estoppel under Malaysian Evidence Act 1950.
Okay, so now let's move on to the application of estoppel in Section 115 of Evidence Act 1950. In Malaysia, the application of Section 115 of the Evidence Act 1950, or known as estoppel by representation, is an extension from the common law. It acts as a rule of evidence. It is provided under Section 115 of this Evidence Act if a person has deliberately induced or falsely allowed another person to believe his assertion, acts or omission to be true, and to act on that belief, neither he nor his representative are allowed to deny the validity of the truth in any suits or proceeding. Estoppel by representation is also related with the maxim of elegans contraria, known as audendius, which means the person alleging contradictory facts should not be heard. Next, we shall see the application of Section 115 of the Evidence Act into the case of Viva Raya against General Manager Kereta Api Tanah Melayu. Appointment has been followed in deciding a recent case of Arab Malaysian Finance Berhad against Kah Motor Company Sdn Berhad, whereby in this case, the court held that there was no estoppel, and it is the duty of the plaintiff to ensure that all the four original documents was served to the defendant directly into the right address in order to prevent fraud.
Muhammad Azmi Judge has quoted Sarkar on evidence which has laid down several requirements to invoke estoppel under Section 115 of the Evidence Act. The first requirement is a statement, act or omission must be a representation by an individual or his designated agent. Second, the representation must be of the nature of reality or fact, not plans of the future that may or may not be enforceable in the contract. Third, the representation must have been intended to be depended on. Fourth, there must have been the confidence in the facts from the other party. Fifth, the declaration, act or omission must have induced another party to act on that faith and to modify or alter his former position. Sixth, the misrepresentation or acts or negligence must have been the immediate cause that has led the other party to behave to his prejudice. 7. The person seeking the advantage of an estoppel must demonstrate that the true state of things was not known to him.
We shall see the application of estoppel in Section 116 of the Evidence Act, or known as estoppel by deed. It provides the right towards the landlord or the licensor from being denied by the tenant or the licensee on their property. 116 of the Evidence Act 1950, it has specifically laid down that during the continuation of the tenancy, no tenant of the immovable property or the person claiming through the tenant shall be permitted to deny the landlord's title over the property, and no person who has obtained any immovable property through the license of the person in possession shall be permitted to deny that person's title at the time of the license has already been issued.
Next, to invoke Section 116 of the Evidence Act, there are two requirements that need to be fulfilled. Firstly, there must be a possession by the tenant to the premises. Secondly, there must be permission for the said possession.
The requirement has further been applied in deciding a recent case of Big Blue Taxi Facilities Sdn Bhd against Pusat Pembangunan Reka Betuk Sdn Bhd. In this case, the court held that Section 116 of the Evidence Act 1950 is applicable based on the fact it has fulfilled both of the requirements, whereby the plaintiff had the possession on the land and it is proven that the possession was with the defendant's permission stated in the letter of undertaking that has been signed by both parties.
So in my part, I will discuss about the other type of estoppel according to our Malaysian law of evidence, other than estoppel by representation and estoppel by deed. So the other type of estoppel is estoppel by record. Estoppel by record has been applied in our Malaysian law through Section 40 to Section 44 of our Evidence Act 1950, where it deals with the relevancy of previous judgment, orders and decrees. As the estoppel by record deals with the relevancy of previous judgment, so the doctrine of res judicata also been adopted to strengthen the use of this estoppel. By using the doctrine of res judicata, it prevents any court from taking any cognizance of subsequent suit, and the purpose of this doctrine is to provide a finality towards a suit. So in a simple word, when a person has been brought to court for a suit, the final judgment will be considered final and the party may not bring another suit with the same cause of action as he was estopped by doing so. On the other hand, it should be noted that even the estoppel by record has a same consequence as the doctrine of res judicata. The distinction between both doctrine can be seen, where the doctrine of res judicata is a matter of procedure, while the estoppel is a matter of evidence. To make it clear, under the doctrine of res judicata, when a dispute between the parties to a final judgment has been litigated, that decision cannot be questioned and the matter resolved cannot be revived. Whereas in the estoppel by record may make certain evidence inadmissible if it be brought again. So in the current case of Consortium Lot Saberkat Sdn Bhd and Petron Malaysia Refining and Marketing Berhad, it is an appeal case by the plaintiff against the decision of the High Court of the Kuala Lumpur in granting the defendant's application to strike out the plaintiff's claim on the ground that the statement of claim is scandalous, frivolous, vexatious, and it is otherwise an abuse of the court process. To make it simple, the plaintiff in this case has brought the case before, and in the first suit, the plaintiff failed in his claim. So in this current suit, the defendant's counsel argued that the matter raised in this current suit has been raised before and decided in the first suit. Thus, the current suit may be stopped and may not be relitigated by applying the application of the doctrine of res judicata and estoppel. So it was held that the judges in the Court of Appeal unanimously dismissed the appeal. So in conclusion, after examining all the discussions presented, it can be concluded that the equitable estoppel has gained ground in Malaysia, both as a rule of evidence and as an area of substantive law. So it should be noted that in applying the doctrine of estoppel in Malaysia, it can be either legal or equitable. As we can see, under the estoppel by representation, estoppel by deed, and estoppel by record, it is a type of legal estoppel, whereas promissory and proprietary estoppel fall under the equitable estoppel and still be applied in Malaysia. Therefore, it is up to court to grant which type of estoppel that is relevant to the case, as it was all about case-to-case basis. So that's all from us, the group of Semprit, and thank you.